Your Honor, first I wanted to extend my thanks to all the parties here and the court and the staff on everyone's hard work and commitment to hold this hearing on an emergency basis to present these issues in a public hearing. And I think this hearing shows that Proposition 103's rate hearings aren't a source of delay, they're a source of process. And we've seen here that that process can be adapted to urgent circumstances when required. Your Honor, this case comes down to the same clear question we started this hearing with. Has State Farm justified an emergency rate increase under California law? The answer is clearly no. First, I want to be clear about what State Farm is not arguing. We're not saying that State Farm can't ever get a rate increase, or that the commissioner can never grant a request for interim rate relief when the legal standard for such relief has been met. All we are arguing is that all rate increases must be legally justified and factually supported, with the burden on the insurer to prove that support through actuarial analysis. If an interim rate is requested, the insurer must first show actuarially that the rate is plainly invalid under Cal Farm. That's it. That's how we prove up rate in rate proceedings, through actuarial work, not through appeals to financial conditions or risks. Now, I'd like to be clear about what I think State Farm wants this court to do. Approve an interim rate hike now, and then prove up its rates later due to State Farm's financial pressures and market concerns, not because of a demonstrated need under the rate formula. What State Farm is really saying is they're saying they're too big to fail. They're arguing their size and market position exempt them from the usual rules. We're not disputing State Farm's importance. Millions of Californians rely on State Farm, and State Farm has every right to ask for rate increases. But under Proposition 103, California's Insurance Consumer Protection Law, they must prove those increases are justified before they take effect. Too big to fail, it's not a legal argument. It's a scare tactic of a parade of speculative horribles. We apply it to serious systemic issues. Here we've heard about insurance market stability, or breakdown in availability, or threats about 680,000 mortgages suddenly needing new policies. When we say these issues aren't relevant here, we aren't saying they aren't important. We're just saying these broader systemic problems, like other too big to fail problems, need a whole of government response. They belong with the legislature, with the governor, the insurance commissioner through his market conduct powers, but they don't belong and can't be allowed to be relevant here in a rate hearing. Now, I'd like to turn to the actual legal standard that we think you must apply, and that's the plainly invalid standard under Cal Farm. This standard does not involve any determination on State Farm's overall financial condition or marketplace conditions. The Supreme Court has set a clear standard for interim rate relief. The insurance commissioner under Cal Farm can adjust plainly invalid insurance rates through interim processes. Now, in this proceeding, just like in Cal Farm at page 824, we've used plainly invalid to refer to rates that are inadequate. Because Proposition 103 prohibits both rates that are excessive and rates that are inadequate, both the high and low bounds of the allowed rates, the rate making formula, and this is a quote from 20th Century Insurance, the rate making formula is used to fix, here's an ellipses in the quote, and then continuing, the range of rates within the bounds of the excessive and the inadequate. That's 20th Century Insurance at page 285. And under Proposition 103's prior approval regulations, a rate is inadequate if it is lower than the minimum permitted earned premium. That's at 10 CCR section 2644.3. And this is the same analysis we see in 20th Century. State Farm has provided no actuarial analysis to justify their request. They've relied on financial conditions and market data, which we argue are factors that should be strictly insulated from rate hearing proceedings, both based on the insurance code and for important public policy reasons. Now, only Consumer Watchdog has presented a thorough actuarial analysis here. And that analysis shows, even when we use State Farm's assumptions and calculations, it shows that State Farm's rates aren't inadequate or plainly invalid, because the minimum rate change shown in State Farm's February 5th prior approval rate template, as Mr. Armstrong discussed in his 5 scenarios, the minimum rate change there is a negative value. And that means the rate isn't inadequate and it's not invalid. So State Farm doesn't clear their first legal hurdle. Abandoning Cal Farm to determine if an insurer is eligible for interim rate relief doesn't leave us with any workable standard to evaluate interim rate relief requests. Every mudslide, wildfire, major atmospheric river event, and as much as we all enjoy living in California, some area or another of California faces these things regularly. All of these events could open the floodgates to insurers demanding emergency interim rate hikes based solely on temporary financial setbacks or market fears. State Farm is the largest insurer, but the second, the third, the fourth largest insurers were also impacted by the recent LA wildfires. They should not qualify for emergency increases without actual aerial support either. And without a clear standard, the commissioner can't evaluate, and this court can't evaluate interim rate requests. Now, the second question that Your Honor has to consider, because this is a stipulation on a settlement, is whether the stipulation as a whole is fundamentally fair, adequate, reasonable, and in the interest of justice. That's the standard for approving a settlement at 10 CCR section 2656.1. Fundamental fairness has to mean, at the very least, evaluating a deal from both sides, including from the viewpoint of consumers. But Dr. Appel, State Farm's expert on market conditions, said that the interim rate increase poses no risk to policyholders. He declared there is an absence of risk to policyholders. That statement completely ignores what it truly means for a family sitting at their kitchen table, struggling to budget their monthly bills, to suddenly see their insurance increase by $40 or $50 a month, based on the average increase of $470 or $600 a year. An extra $40 or $50 a month can be a significant hardship for many California families. For many, this increase could mean choosing between paying for groceries, for medication, for childcare, or even just keeping the lights on. It's simply not credible to dismiss this hardship as no risk or an absence of risk. It's clear Dr. Appel evaluated the settlement solely from State Farm's perspective and the market's perspective. He said the interim rate increase is not only reasonable and justified, but in fact critical to the health of State Farm and the California homeowners insurance market. Now, we assume the settlement is good for State Farm because they've agreed to it. Perhaps it's good for the market, but this entirely disregards consumer hardships and realities. This isn't fairness, and that's one-sided advocacy from Dr. Appel. There are multiple risks that policyholders face here. They could be forced to find more affordable coverage. They'll have to immediately begin higher rates. And there's no guarantee in any of the stipulations that they won't be dropped the next time their policies come up for non-renewal after the non-renewal periods end. Dr. Appel also thinks the insurance commissioner's main job is protecting insurance companies from going broke. He told us that the commissioner's primary role is maintaining the solvency of insurers. But Commissioner Lara himself disagrees. In his letter of February 14th in this matter, he stated clearly, my primary responsibility is to the people of California. That's at Exhibit 149, page 3. The commissioner's letter also emphasizes that Proposition 103 expressly precludes him from approving rates that are excessive, inadequate, unfairly discriminatory, or otherwise in violation of the insurance code. And he emphasizes the burden is on the insurer to demonstrate and support its rate requests. All of this, prior approval, demonstrated support for requests, all of this State Farm is asking you to disregard and just to look at financial condition in a one-sided way because they've asked for this rate increase. Now, part of State Farm's argument about the fundamental fairness of this stipulation is that even if the stipulations aren't fair, that's okay because refunds will fix it. But refunds at some unknown future date, after State Farm exhausts all of its legal remedies, if it doesn't think the final rates ordered are too low, if it does think the final rates ordered are too low, won't fix the immediate harm that families here face. Families who must rearrange their budgets now or have to cut back on essentials. Refunds also won't help families who need money now who are still recovering from the recent fires. This is what Proposition is supposed to do, protect consumers by requiring insurers to justify their rates first before they take effect to prevent this kind of immediate irreversible harm. Now, there's evidence here on adequacy and reasonableness, which are the next two factors that you have to consider. There's only one actuary for the proponent of the two-way stip, and that's Ms. Shaw. She's the only expert who testified on the numbers of the interim rate proposal. And she thinks that an increased rate is unlikely to be sufficient by itself to affect long-term improvement to State Farm's financial condition. She further explained here in testimony that State Farm needed to look at its other rates. And State Farm is, because there are other rates involved in here. There's the renters and the rental property. But homeowners is the driver here as far as numbers go. And that's the number we've looked at most frequently here in this proceeding. Because there's no argument that homeowners is the driver as far as the costs go. So if the homeowner's rate increases alone, well, won't help improve the number one problem that State Farm's witness, Dr. Appel, and the department's witness, Ms. Shaw, identify, which is financial condition, then why are we considering taking money from consumers and giving it to an insurer before a rate hike is justified when the department's own witness doesn't think a higher homeowner's rate alone is a long-term fix? Why implement a cure that won't work? That's not adequate. That's not reasonable. Shaw also says that she needs information. She says this is very early stage preliminary analysis. She says she intends to further investigate and develop during discovery as part of the full rate hearing process because she believes there are other steps that State Farm should be encouraged and required to take to improve its condition and financial condition. It's fine to need more information to better understand State Farm's rate increases. Consumer Watchdog needs that information too. But this is a request to go to a full rate hearing with full discovery, not a reason that a stipulation is adequate or reasonable. And again, refunds can't make the stipulation adequate or reasonable, just like they can't cure the stipulations to make them fair. It's not reasonable to take money from someone in violation of the law, here Proposition 103, with a future conditional promise to maybe pay some of it back. The last factor this court must consider under Section 2656.1c is the interest of justice, which invokes many concepts of equity and justice and the rule of law, but all of these revolve at the core about respecting and following the law. Here we think the law is clear. It's Cal Farm. That gives the standard to see if the interim rate is warranted in the first instance, or if the applicant should proceed to a full rate hearing. If the current rate is plainly invalid through actuarial analysis, that is, it's inadequate under the regs, then an interim rate should be considered. But as we've seen, Mr. Armstrong, the only actuary who ran through these calculations, doesn't find that the rate is inadequate. It's not plainly invalid, even using all of State Farm's assumptions. This is all clearly defined in the regulations, and the commissioner has a duty to prevent inadequate rates, just as much as he must prevent excessive rates. The interest of justice also must mean following the regulatory standards for approving settlements. And we've explained here that the proponents of the stipulation, their witnesses and evidentiary support, they don't meet these standards. Mr. Earhart talked about reinsurance to rebut some criticism that Consumer Watchdog raised about State Farm's business decisions, but he doesn't address the fundamentally fair, adequate, reasonable, or interest of justice standards at all. Dr. Appel, he dismisses the risk to consumers. That's not fairness. Mrs. Shaw doesn't speak to the adequacy or reasonableness. She's taking numbers that were given to her, acknowledging that more parental support would be better. More money would help more from the parent. But she also doesn't think a homeowner's rate increase by itself would help in the long term, and she wants more information through a full rate hearing. Ms. Shaw raises significant issues, and all of these issues need a full rate hearing. We think Ms. Shaw is correct in wanting more information in a full rate hearing so that a determination can be made on the appropriate rate based on a full record. State Farm can and should make its case fully in that setting, but granting an unjustified interim increase now undermines Proposition 103 and hurts California families. We respectfully ask you to reject the two-way stipulations for the proposed interim rate increases and send this matter to proceed to the full evidentiary hearing that's already noticed on as expedited a schedule as the parties in court can accommodate. That ensures fairness, accountability, and adherence to California law. Thank you.
Thank you.